At the beginning of the case, number 05C910, there were only 4 elements needed to prove copyright infringement: originality, access, similarities, and citizenship, all of which Chitunda Tillman Sr. submitted, yet still he hasn't received a trial by jury. Number 1. Originality. Mr. Tillman Sr.'s original 1998 KHOG copyright matches exactly what the 2002 feature film John Q, starring Denzel Washington, was all about. Take a look. A black family struggle with a heart situation, with no warning and no insurance to pay for it. Wasn't that the exact storyline for John Q? The answer is yes. See for yourself. Number 2. Access. Access is the second threshold, proving copyright infringement. It is clear that the WGA West had access to Mr. Chitunda Tillman Sr. original script in 1998 about a heart situation with no warning or insurance. Here's WGA West proving that they had access to Mr. Tillman's script in 1998. Mr. Chitunda Tillman Sr. proves the scripts are similar. Similarity between Tillman's copyright, page 25, and John Q, page 18. So what about citizenship? Clearly, Mr. Chitunda Tillman Sr. won his case on the merits by satisfying the court's requirements. So what happened? Can you say perjury? Kearns swore he registered John Q with the WGA in 1993, as you can see here on page 6. Because Mr. Chitunda Tillman Sr. beat the defendants on the 1998 copyright claims, Time Warner had to create articles in order to justify the theft of Mr. Tillman's original screenplay, Krog, by attempting to fabricate an article from an early date to establish a timeline for 1993. Now let's take a look at these fabricated articles. The second and last relevant article the defendants provided to Mr. Tillman Sr. was this Hollywood Reporter article speaking of a title, John Q. But if this article was supposed to prove that James Kearns wrote John Q, then why isn't his name in the article? In fact, Denzel Washington's name is not even in the article. The reason for this is because the Q in John Q actually stands for Mr. Chitunda's childhood friend, whose name is Quincy. Kearns was paid by WGA West. These payments reflect dates after 1998, No payments were issued to Kearns in 1993 or 1994. Also, if New Line made John Q with Kearns and shared copyright credit with Kearns, page 9, then why did the WGA West pay Kearns? So, if this isn't the same Kearns who worked for WGA West, it's all good, right? Do all members get $96,708.83 checks or employees? The WGA West also paid his health insurance. This clearly sounds like an employee-employer relationship. The courts also protected the defendants. Did you know that Time Warner paid the judges off? Time Warner and the defendants never answered a single question. James Kearns committed perjury. Look again at his second declaration, number 5. Then, James Kearns, if you swore in court that you didn't know that you needed a copyright to protect the work, then what do you mean? Are these not copyrights in your name submitted by you to the Copyright Office? You lied. You committed perjury. Some of these were created before the alleged 1993 John Q copyright. Yet John Q wasn't copyrighted until 2000. 2 years after Mr. Chatunda Tillman Sr. 1998 copyright, Mr. Chatunda Tillman Sr. is a real man. It was your classic bait and switch. The courts blocked Mr. Tillman from cross-examining any witnesses. Angela Clare, New Line Cinema secretary, swear that she now copyrighted John Q and not Kearns. Can you believe it? Please note, November 27, 2007 was the discovery cutoff date, so how was Mr. Tillman going to respond? The court finally admitted that Mr. Chatunda Tillman Sr.'s script and John Q were similar. Wow. So if you didn't steal his script or see his script, they should not be similar on no level, general or otherwise. It is clear, according to the courts, that Mr. Chatunda Tillman Sr. proved the elements to survive summary judgment and proved copyright infringement of his original screenplay, Charisma, Heart of Gold, or Korg, copyright 1998. In fact, defendants stated that they couldn't even argue that Mr. Chatunda Tillman Sr. had a valid U.S. copyright because they couldn't argue the written expression on the valid copyright with Mr. Tillman Sr., stating that the film was about a black family with no warning or no insurance to pay for the heart situation, the exact plot, etc. of the film. Mr. Chatunda Tillman Sr. has already proven that the defendants had access to his copyright script Korg in 1998. Notice the defendants Time Warner and New Line et al. Sticks to the 1993 lie, which we now know the truth. Judge Kennelly of the U.S. District Court in Illinois states that copyright doesn't matter in Mr. Tillman's case. In Judge Kennelly's unfair ruling, trying to explain away Angela Clare, saying she copyrighted John Q and not Kearns, even though for over 2 years Kearns said he copyrighted John Q, this should prove conspiracy to steal Mr. Tillman's work. The judge then states the defendants had access to Mr. Tillman's Korg, Charisma, Heart of Gold in 1998, but didn't look at it? What is going on here? In spite of all the lies, Mr. Chatunda Tillman Sr. fought Time Warner et al. All the way. This is the company that actually made John Q with New Line Cinema, starring Denzel Washington, whom Mr. Tillman chose for the part, using his script, Korg, Charisma, Heart of Gold, in early 1998. Notice anything about the year, date of this company's creation. What an interesting coincidence. Please support the real author of John Q. Visit his website today, www.therealjohnq.com.